At 2:47 this afternoon, inside a federal courtroom in Manhattan, something happened that has never occurred in the 249-year history of the American presidency. A sitting federal judge held Donald Trump in contempt of court and issued a direct order with a deadline that expires in exactly 72 hours. I need you to understand the weight of what I am about to tell you. This is not political theater. This is not another headline that will fade by tomorrow morning. What happened today is a stress test on whether our democracy can actually function when someone decides the rules simply don't apply to them. If you care about what happens to this country over the next 3 days, you need to subscribe to this channel right now and turn on notifications, because the 72 hours ahead will determine whether American institutions still have a functioning immune system, or whether we have crossed a threshold into something we have never seen before. Here is what we know. 3 independent sources, 2 from inside the courthouse, and 1 close to the federal prosecutor's office, have confirmed to us exactly what transpired in that sealed hearing. The contempt order was not some procedural formality. Judge Catherine Delgado issued a direct mandate requiring Trump to produce documents that his legal team has been blocking for 8 months. The deadline is Friday at 5 p.m. Eastern Time. According to the official court transcript, which was sealed, but portions of which were described to us by someone who reviewed it within hours of the hearing's conclusion, the judge stated, continued defiance would result in daily fines starting at $50,000 and escalating by $25,000 each subsequent day until compliance is achieved. This is not a suggestion. This is an enforcement mechanism designed to compel action from someone who has spent his entire life avoiding consequences. Now let me walk you through exactly how we got here, because the timeline matters enormously. This did not happen overnight. This was a cascade of defiance, legal maneuvering, and institutional patience finally reaching its breaking point. Tuesday, August 12th, the Department of Justice filed a motion to compel production of financial records related to foreign business transactions between 2017 and 2021. These are not personal tax returns. These are corporate documents involving entities registered in at least 4 different countries, documents that federal investigators believe show patterns of unreported income and potential violations of the Foreign Corrupt Practices Act. The motion included 247 pages of supporting evidence, demonstrating that Trump's legal team had been given multiple opportunities to comply voluntarily and had refused each time. Wednesday, August 13th, Trump's attorneys filed a response that legal observers immediately recognized as a stalling tactic. The filing argued that the documents requested were overly broad, that they infringed on executive privilege despite Trump no longer holding office, and that compliance would cause irreparable harm to ongoing business operations. Former federal prosecutor Jennifer Lawson, who spent 12 years handling white-collar cases in the Southern District of New York, told reporters that the arguments were legally frivolous and designed purely to buy time. She pointed out that executive privilege claims have been rejected in every similar case involving former presidents, and that the irreparable harm argument made no sense given that these were historical records, not current operational documents. Thursday, August 14th, the hearing that was supposed to be routine procedural discussion turned into something no one expected. According to 2 people who were present in the courtroom, Judge Delgado spent the first 20 minutes reading portions of Trump's response aloud, pausing after certain passages to note that the legal reasoning contradicted established precedent. One observer described the atmosphere as tense silence, with Trump's legal team visibly uncomfortable as the judge dismantled their arguments point by point. Then came the moment that changed everything. Judge Delgado stated that she had reviewed the government's evidence demonstrating 8 months of refusal to comply with lawful document requests and that the pattern indicated willful obstruction rather than good faith legal dispute. She issued the contempt finding on the spot and set the Friday deadline for full compliance. Now, before we go further, if you are finding this valuable, hit that like button right now, because this story is about to get significantly more complicated and you will want to be here for all of it. The algorithm rewards engagement, and your like helps this reach people who deserve to know what is actually happening before the spin machine buries the truth. Let me tell you who Judge Catherine Delgado actually is, because this context matters. Delgado was appointed to the federal bench in 2019 after serving 15 years as a federal prosecutor in the Southern District of New York. She has a reputation among legal practitioners as meticulous, fair, and utterly intolerant of procedural games. During her tenure as a prosecutor, she successfully convicted 14 high-profile white-collar defendants with a conviction rate that placed her in the top 5% nationally. When she was nominated to the bench, she received unanimous approval from the American Bar Association and was confirmed by the Senate with bipartisan support. This is not some activist judge with a political agenda. This is someone who has spent her entire career enforcing the law without regard to the defendant's wealth, power, or public profile. Here is what concerns me most about what happened in that courtroom. Judge Delgado did not just issue a contempt finding. She created an enforcement mechanism designed specifically to address someone who has historically viewed fines as the cost of doing business. The escalating daily fine structure means that within 2 weeks of continued defiance, Trump would be facing daily penalties exceeding $300,000. Within a month, over $1 million per day. According to constitutional law professor David Chen from Georgetown, who has studied contempt enforcement mechanisms for 20 years, this graduated penalty structure is extremely rare and signals that the judge has studied Trump's history of using wealth to simply absorb financial penalties without changing behavior. Chen explained that the structure is designed to reach a point where even someone with substantial resources must make a choice between compliance and financial devastation. But here is where it gets really bad. What I am about to tell you is not speculation. This is reconstruction based on multiple sources familiar with discussions happening inside Trump's legal team right now. They are facing a problem that they have never encountered before in 8 years of legal battles. Every previous strategy has relied on delay, appeal, and waiting for political winds to shift. But contempt findings are different. They cannot be appealed until after compliance, or until penalties accumulate to a level that constitutes irreparable harm. That threshold, according to legal precedent, is extremely high, typically requiring proof that the penalties would cause complete financial ruin rather than mere significant expense. Trump's visible wealth makes that threshold nearly impossible to reach. Subscribe now if you want to follow where this leads, because the implications are staggering and mainstream media will be 3 hours behind everything I am showing you. The question legal experts are asking right now is not whether Trump can win on appeal. The question is what happens when someone simply refuses to comply despite mounting penalties. This is uncharted territory. Here is what most people do not understand about the documents at the center of this case. These are not just financial records. According to 2 sources who have been briefed on the contents of the government's sealed evidence, these documents allegedly show a pattern of unreported income from foreign sources totaling somewhere between $40 and $60 million between 2017 and 2021. The money allegedly moved through shell corporations registered in the Cayman Islands, through a Luxembourg holding company, and eventually into U.S. bank accounts controlled by Trump Organization entities. The pattern allegedly matches what federal prosecutors call layering, a technique used in money laundering operations to obscure the original source of funds by moving money through multiple jurisdictions and corporate structures. Now I need you to understand something about federal courts and document production orders. When a judge issues a contempt finding with a compliance deadline, there are only 3 possible outcomes. First, the defendant complies and produces the documents. Second, the defendant proves that compliance is impossible because the documents do not exist or cannot be located despite good faith effort. Third, the defendant continues to refuse and faces escalating penalties, leading eventually to potential incarceration for contempt. That third option is almost never pursued because the financial and legal costs become unsustainable. But what happens when the defendant decides that the contents of those documents are more dangerous than any penalty the court can impose? Former appellate judge Patricia Hammond, now retired after 30 years on the federal bench, explained in an interview this evening that contempt cases involving document production almost always end in compliance because defendants recognize that the alternative is worse. But she added something that should make everyone pay attention. She said that in her entire career she encountered exactly 2 cases where defendants chose escalating contempt penalties over document production. In both cases, the documents ultimately revealed criminal conduct serious enough that the defendants calculated that disclosure would result in more severe consequences than contempt penalties. When the documents were finally produced under court order after months of defiance, both defendants were subsequently indicted on multiple felony counts. And it gets worse. Sources close to the federal prosecutor's office indicate that the government has already obtained some of the requested documents through subpoenas to third-party banks and financial institutions. That means prosecutors already know what the Trump Organization documents should show. The document request is not a fishing expedition. It is an attempt to force Trump to either produce records that match what prosecutors already have, proving cooperation, or to produce records that conflict with what prosecutors already have, demonstrating potential evidence tampering or document destruction. This is a classic prosecutorial technique. You already know the answer. You are testing whether the subject will tell you the truth. If you are still watching and you understand why this matters beyond partisan politics, smash that like button right now. Every like tells the algorithm this story matters and helps push this analysis to more people who need to understand what is really happening before it is too late. Let me show you what happened over the last 6 hours since Judge Delgado issued her order. At 4:15 p.m., less than 90 minutes after the hearing concluded, Trump posted on social media calling the contempt finding a witch hunt and a disgrace to the judicial system. Legal analysts immediately noted that attacking a sitting federal judge while under contempt order is extraordinarily risky because judges have broad discretion to impose additional sanctions for statements that could be interpreted as attempts to intimidate or undermine court authority. By 6:30 p.m., Trump's lead attorney issued a statement saying they are evaluating all legal options but notably did not commit to compliance with the Friday deadline. That careful language tells experienced legal observers everything they need to know. If Trump's team intended to comply, they would have said so immediately to avoid further antagonizing the judge. The fact that they are evaluating options suggests they are looking for ways to continue resisting. Here is what I am watching for in the next 48 hours that should terrify anyone who cares about institutional stability. Trump has 3 choices, and none of them are good. Choice 1, he complies, produces the documents, and faces whatever legal consequences flow from their contents. Choice 2, he continues to defy the order, pays escalating fines, and hopes that political pressure or an appellate court intervenes before the situation becomes financially catastrophic. Choice 3, he attempts to destroy or alter the documents and claims they were lost or no longer exist, which would constitute obstruction of justice and evidence tampering, federal crimes carrying mandatory prison sentences. According to someone who has worked with Trump's legal team on previous matters and who spoke on condition of anonymity, Trump's instinct in situations like this is always to fight, delay, and attack rather than comply. But this person also said that Trump's attorneys are reportedly telling him that this situation is different because the judge has designed an enforcement mechanism specifically calibrated to his known patterns of behavior. They are telling him that the financial penalties will eventually exceed what even his resources can absorb, and that continued defiance could result in criminal referrals that make his current legal problems look minor by comparison. Make sure you are subscribed with notifications turned on, because this story is far from finished. When Friday arrives, when we see whether Trump complies or defies, when the next phase of this enforcement action begins, you will see detailed analysis here immediately, before mainstream outlets even understand what they are watching. Now here is where this gets genuinely dangerous for the stability of our institutions. Constitutional scholars are already discussing what happens if a former president simply refuses to comply with a federal court order regardless of penalties. Professor Michael Torres from Yale Law School published an analysis this evening, arguing that we are potentially heading toward a constitutional crisis that tests whether judicial authority means anything when facing someone willing to absorb unlimited financial penalties. Torres pointed out that the ultimate enforcement mechanism for contempt is incarceration, but jailing a former president for civil contempt would be unprecedented and would require law enforcement willingness to execute that order against someone with Secret Service protection and a large base of political support. Let me bring this together because we are running out of time and the clock is ticking faster than most people realize. Here is what all of this means. We are 72 hours away from finding out whether the rule of law still functions in America when applied to someone who has spent 8 years demonstrating that he believes rules are for other people. Judge Delgado has created a test case. She has designed an enforcement mechanism specifically to address Trump's pattern of using wealth and delay to avoid accountability. Now we find out if it works. Let me lay out the three scenarios that are now on the table. Scenario 1. Trump complies by Friday at 5 p.m. and produces the documents. Probability, I give this 25%. If this happens, federal prosecutors immediately begin analyzing the documents for evidence of foreign income reporting violations, potential money laundering, and Foreign Corrupt Practices Act violations. The documents either match what prosecutors already obtained from third-party sources, which provides no new legal jeopardy, or they conflict with those sources, which creates new evidence of potential document tampering. Either way, Trump's legal exposure increases significantly. Scenario 2. Trump refuses to comply and begins paying the escalating fines while his attorneys file emergency appeals trying to block the contempt order. Probability, 50%. This is the most likely outcome based on Trump's historical behavior pattern. If this happens, we enter a weeks-long legal battle where Trump pays increasing daily fines while appellate courts decide whether Judge Delgado's order was proper. The fines could reach millions of dollars before any appellate decision, and legal precedent strongly suggests the contempt order will be upheld because document production orders in criminal investigations have consistently survived appellate review. This scenario eventually leads back to Scenario 1 or Scenario 3, but with massive financial costs and months of additional delay. Scenario 3. Trump claims the documents cannot be produced because they were lost, destroyed in normal business operations, or never existed in the form prosecutors describe. Probability, 25%. If this happens, prosecutors immediately launch an obstruction investigation, examining when the documents disappeared, who had access to them, and whether their destruction was intentional. Given that prosecutors have already obtained some of these documents from third-party sources proving they existed, any claim that they are lost would face immediate skepticism. This scenario likely leads to additional criminal charges for obstruction of justice and evidence tampering, federal offenses that carry mandatory prison sentences and cannot be resolved through fines or settlements. But here is why this matters beyond this one case. The stakes go far beyond Donald Trump and far beyond one set of financial documents. What we are witnessing is a fundamental test of whether American institutions can enforce basic accountability when facing someone who has built an entire political identity on the idea that he is above the law. If Trump successfully defies this court order without consequences, what message does that send to every future defendant who decides that compliance is optional? If a federal judge cannot compel a former president to follow the same document production rules that apply to every other American, then what does that say about equal justice under law? So what can you actually do about this? Because I know a lot of you are watching this feeling powerless. Here is how you make your voice heard. First, contact your congressional representatives and demand that they support judicial independence and speak out against attacks on federal judges. When Trump attacks Judge Delgado, when he calls this a witch hunt, your representatives need to hear from constituents that Americans support judges who enforce the law without regard to defendant wealth or power. Second, stay informed and share accurate information. The spin machine is already working overtime trying to portray this as political persecution. Counter that narrative by sharing analysis like this that explains what is actually happening and why it matters. Third, if you believe in institutional accountability, make your voice heard in the comments section below. Tell me what you think happens on Friday. Do you think Trump complies, defies, or tries to claim the documents are gone? I read every comment. Subscribe to this channel right now, because when Friday arrives at 5 p.m, I will bring you immediate analysis of what happens next. This is not over. This is just beginning. The next 72 hours will determine whether our institutions still have teeth or whether we have entered an era where power and defiance are their own form of immunity. What happens next will set precedents that echo for decades. Drop a comment below and tell me which scenario you think is most likely. I want to hear from you because your voice matters in this moment. The stakes have never been higher, the evidence has never been clearer, and the clock is ticking toward a deadline that will define whether accountability still means anything in America.